Kate Feeks. Welcome to this edition of Medina County Court News. On Thursday, February 16, 2012, Mr. Trevor E. Freeman of Brunswick, Ohio, appeared in court with his attorney Michael Callow on one charge of receiving stolen property, a fifth-degree felony. Here is Judge Kimbler taking Mr. Freeman's change of plea.
Calling case number 11-CR-0689, State of Ohio versus Trevor Freeman. Let the record reflect that Mr. Freeman's in court with attorney Michael Callow. The State of Ohio is in court with attorney Matthew Razabi, and we are here today for a change of plea.
No, sir.
You are here today on a criminal case. In a criminal case, there are 4 pleas that you may enter. They are a plea of guilty, which is not guilty, which is total denial of each and every element of the crime. A plea of not guilty by reason of insanity, since you did the act or you're legally insane. A plea of guilty, which is total admission of your guilt, and a plea of no contest. A plea of no contest is not an admission of your guilt, but it is an admission of the truth of the facts set forth in the charging document. If the facts set forth in the charging document constitute a criminal offense, you can and will be found guilty on a plea of no contest and treated as if you pled guilty, but the fact you entered that plea cannot be used against you in a subsequent civil or criminal court case. Do you understand those pleas?
Yes, sir.
If you enter a plea of guilty or a plea of no contest, you are giving up or waiving certain valuable and important constitutional rights, and these rights are as follows. The right to a trial by jury, to have your guilt proven by proof beyond a reasonable doubt, to subpoena witnesses on your own behalf, to cross-examine those witnesses called in state against you, to have the services of your attorney at trial. You're giving up your right not to incriminate yourself, and you're giving up your right to a speedy trial. So you understand you're giving up your right.
Yes, sir.
You understand if you went to trial, you would not have to testify, and the fact that you did not testify cannot be used against you.
Yes, sir.
So you have one count of receiving stolen property, right?
Yes, sir.
You're charged on the 3rd day of November 2011 in the county of Medina, State of Ohio. You did not only receive, retain, or dispose of certain property, to wit jewelry, the property of another, 1 KD, knowing or having reasonable cause to believe the property had been obtained for the commission of a theft offense, the value of the property being $1,000 or more, but less than $7,500, in violation of 2913.51A of the revised code, and this is a felony of the 5th degree. You understand the nature of the charge?
Yes, sir.
They'll carry a possible prison sentence of 6 months to 12 months in 1 month increments, a fine up to not exceeding $2,500. If you went to prison for this offense, and only if you went to prison for this offense, when you were released from prison, the State of Ohio could, but would not have to, put you under what's called post-release control, which means that for a 3-year period, you'd be subject to the control of the Adult Parole Authority, and if you committed another offense during that period, or violated certain rules and regulations of the Adult Parole Authority, they could put you back into prison for up to 1/2 the time I gave you, independent of, in addition to any of their penalties. You understand that?
Yes, sir.
Anybody make any threats or promises to get you to change your plea?
No, sir.
Have you told Mr. Callow everything there is to know about this case?
Yes, sir.
Are you satisfied with his services?
Yes, sir.
Any questions for myself?
No, sir.
Need to talk to Mr. Callow outside my presence.
Yes, sir.
Okay. And I'm seeing the questions for you. Do you understand the nature of the charge?
Yes, sir.
Do you understand the nature of the potential penalty?
Yes, sir.
How do you plead?
No contest.
Waive statement of facts. And do you now withdraw your plea of not guilty?
Yes, sir.
Anything further from the State of Ohio on the change of plea?
No, Your Honor.
Anything further from defense counsel on the change of plea?
No, Your Honor.
Court finds to the record that Mr. Freeman made a knowing, voluntary, intelligent change of plea. Court took the change of plea after he was satisfied by inquiry that he did understand his criminal rule 11 of constitutional rights. He did make the plea in open court and upon the record. Therefore, the court does find him guilty of 1 count of receiving stolen property in violation of RC 2913.51 a felony of the 5th degree. Does order a PSI. Will impose sentence after the PSI on March 22nd, and you're not seeking revocation of bond, are you? His bond is continued. Thank you. Can I see counsel at sidebar along with Mr. Chan?
This is Kate Feeks, thanking you for watching this edition of Medina County Court News.
Excellent.